Ladies and gentlemen, welcome to the National Constitution Center. I am Jeffrey Rosen, the president of this wonderful institution. On this day of all days, it is especially important to recite our congressional mission and to remind ourselves that the National Constitution Center is the only institution in America, chartered by Congress to disseminate information about the U.S. Constitution on a nonpartisan basis. When the Anti-Defamation League and the National Constitution Center 8 months ago planned to have this panel on the day that President Trump nominated a replacement for Justice Anthony Kennedy, the day after the 150th anniversary of the 14th Amendment, we anticipated exactly how relevant and timely it would be. And we were excited to assemble 3 of America's most insightful, dynamic, and important legal commentators to educate you at this extraordinary time in American history. I have just one request before I turn the mic over to my distinguished colleagues. We're about to experience the most contentious confirmation debate that the country has seen since the nomination of Robert Bork and Anthony Kennedy in 1987. You can rest assured that the Constitution Center will continue to assemble the best voices from all sides of the constitutional spectrum to debate and explore areas of agreement and disagreement in what is, as intended by the framers, a highly partisan process. This is my homework, though, to you as you read the news and engage with the remarkable debate we're about to have. Don't assume that it's all politics when it comes to the nomination itself. When you look at past hearings since Bork, you will find that far from being a kabuki dance, as they've been widely dismissed, these hearings are remarkably illuminating in revealing the specific judicial philosophies of the nominees and helping us understand how they will behave on the bench. It is not the case that constitutional law is all politics. This is one of the central missions of the Constitution Center. You must, as citizens, understand the differences between the judicial philosophies, which include textualism, originalism, a focus on constitutional structure, precedent, pragmatism, and moral reasoning. Those are 6 of the constitutional methodologies. Both on the current court, liberals and conservative justices embrace both of those methodologies at different times. So we have liberal and conservative pragmatists like Justices Roberts, Kagan, and Breyer. And we have originalists like Justices Thomas and Gorsuch, and we have moral reasoning proponents like Justice Kennedy and Justice Sotomayor. So as you look at Judge Kavanaugh and as you look at the debates before you, don't assume it's 5 Republicans versus 4 Democrats. View everything in constitutional terms and educate yourself about the constitutional stakes. That's my homework, and now it is my great honor to turn the mic over to the distinguished moderator of this panel. We're so grateful for our collaboration with the Anti-Defamation League, and the panel today will be moderated by Melissa Garlick, who is the Civil Rights National Counsel at the ADL. She will introduce our incredible panelists, Erwin Chemerinsky, Fred Lawrence, and Dahlia Lithwick. Please welcome all of them, including Melissa Garlick.
Hello, and welcome to the Anti-Defamation League's 19th Annual Supreme Court Review. I'm Melissa Garlick. Thank you so much, Jeff, for the kind introduction, ADL's Civil Rights National Counsel. We're pleased to be broadcasting live from the National Constitution Center in Philadelphia for the 6th consecutive year, and particularly at a time and day when conversations around the Supreme Court and its future are at the epicenter of public debate. I want to thank the staff here at the National Constitution Center, particularly Jeffrey Rosen and Tanea Tauber, who have worked tirelessly behind the scenes to make today possible. I have the distinct pleasure of being up on stage with our distinguished panelists, and I know we are all very excited to hear from them. But before we start, I just want to recognize the amazing group of lawyers and counsels around the country who led in filing ADL briefs in the cases we will be talking about today. Some of them are in the room: our National Legal Affairs Chair, John Harris, our Vice President of Civil Rights, Steve Freeman, our Washington Counsel, Michael Lieberman, and our Northeast Civil Rights Area Counsel, Amy Feynman. There are also so many people working behind the scenes at ADL to make today possible. I want to say a special thank you to Nancy Barron-Bear, our Philadelphia Regional Director, Leda Tremblay, Ilana Rosenbaum, our web and video team responsible for this live streaming, and my colleagues and our friends at law firms who are hosting programs around the country today. Before we get started, just a tiny bit of housekeeping. For those of you seeking CLE credits today, there will be 2 codes that will scroll across the bottom of your screens at different times during the program. Please make a note of those codes, and for those of you watching on your computer, you should have received a link to an evaluation form. To receive CLE credit, you have to fill in the CLE forms on that codes on that form and submit it no later than July 31st. If you're watching at an ADL event, please fill in the codes on the evaluation forms provided to you. We will be taking questions at the end of our program, and I anticipate there'd be no shortage of questions today. For those of you in the room, you will have an opportunity to write questions on index cards, and for those of you watching around the country, you can submit questions via the website sly.do. We will have instructions that will appear on your screen. The event code is ADL Supreme Court Review, one word, and passcode is ADL 1913, one word. And we hope you'll join the conversation. For those of you joining for the first time who may not be familiar with ADL's work, ADL was founded in 1913 with the mission to stop the defamation of the Jewish people and secure justice and fair treatment for all. We work on a broad range of civil rights issues that hang in the balance after the Supreme Court term, making our discussions around the role of the judiciary more important than ever. We filed amicus briefs before the Supreme Court in a number of the cases we'll be discussing today, including the challenge to the travel ban, as well as in cases around the country at the lower courts, challenging the president's decision to repeal DACA, penalize so-called sanctuary cities, and broaden the religious exemption to the contraceptive mandate of the Affordable Care Act. So we have what I think will be an exceptionally interesting program today at this critical moment. Our panelists will talk about the future of the Supreme Court, not only about the term's key cases, but also about last night's news and the president's nomination of Judge Brett Kavanaugh to fill the Kennedy vacancy. We have a lot to discuss in little time, so let's get right to it. You can find more about each of the presenters in your booklets, but I'll just say a few words about each of our esteemed panelists. Immediately to my left, Erwin Chemerinsky is the Dean of UC Berkeley School of Law. I believe this month marks his 1-year anniversary, so congratulations. One-year anniversary. Before assuming his post at Berkeley Law, Erwin was the founding dean and distinguished professor of law at the University of California, Irvine School of Law, one of the leading scholars on constitutional law, federal practice, civil rights, and civil liberties, and appellate litigation. Erwin is the author of 10 books and more than 200 articles in top law reviews. In January 2017, National Jurist magazine named him the most influential person in legal education in the United States. To his left, Fred Lawrence is the secretary and CEO of Phi Beta Kappa Society, America's first and most prestigious honor society. He is also a visiting professor at the Georgetown Law School and the McCourt School of Public Policy at Georgetown University, and has previously served as president of Brandeis University, my alma mater, dean of the George Washington University Law School, and visiting professor and senior research scholar at Yale Law School. An accomplished scholar, teacher, and attorney, Fred is one of the nation's leading experts on civil rights, free expression, and bias crimes. And last but certainly not least, Dahlia Lithwick is a senior editor at Slate, where she writes the Supreme Court dispatches and jurisprudence columns. She hosts the amazing podcast Amicus, and she has been a guest commentator for the New York Times editorial pages. Her work has appeared in the New Yorker, the Washington Post, Commentary, and you may have seen her on TV a lot yesterday. Please join me in welcoming Erwin Chemerinsky, Fred Lawrence, and Dahlia Lithwick. All right, so let's get right to it. Erwin, let's start with you. This has no doubt been an unusual term on the heels of several major decisions that were handed down at the end of the term negatively impacting immigration, refugee rights, worker rights, voting rights, reproductive rights. We then learned days later of Justice Kennedy's decision to retire. And late last night, we learned of the president's nomination of Judge Brett Kavanaugh, which we'll discuss more at the end. But initially, what are the major takeaways and themes from this year?
It's such an honor and pleasure to be part of this program again. It's wonderful to get to do Dahlia and Fred and Melissa. I was trying to think of a title for the term. I was thinking maybe The Empire Strikes Back would be appropriate. Or I was thinking of a simple title, Elections, or more specifically, the Electoral College Really Matters. The Supreme Court decided 59 cases with signed opinions after briefing and oral arguments. That's the fewest number of cases with signed opinions since 1864. The conservatives prevailed in virtually every major decision. I think one statistic is particularly revealing. There were 18 5-4 decisions. In 13 of them, Justice Kennedy joined together with Chief Justice Roberts, Justice Thomas, Alito, and Gorsuch to create the majority. In 0 of the 5-4 cases did Justice Kennedy join together with Justice Ginsburg, Breyer, Sotomayor, and Kagan. To put this in context, a year ago when the court was divided 5-4, Justice Kennedy joined with the 4 liberal justices in 57% of the cases. I think we're going to regard October term 2017, the year that we're talking about now, as the beginning of a new era in the Supreme Court. Eras in the Supreme Court last a long time. There was an era from the 1890s to the 1930s when the Supreme Court was extremely conservative. During that time, the court struck down over 200 federal, state, and local economic and social welfare laws. Then there was an era from 1937 to 1969. For almost all that time, the majority of the justices appointed by Democratic presidents. The court became progressively more liberal, especially in the 1960s. The next era began in 1969, when Richard Nixon appointed 2 justices to the court, and then 2 more 2 years later. From 1969 on, there's always been at least 5, and sometimes as many as 8 justices appointed by Republican presidents. But all through this era, up until last term, there was a swing justice on the court, a Lewis Powell, a Sandra Day O'Connor, and Anthony Kennedy, who in some key cases would join with the liberals. To be sure, overall, the court was conservative during this era, but there were notable exceptions to that because of the swing justice. Last term on the court, there was no swing justice on the court. Justice Kennedy simply didn't swing. He was solidly anchored with the conservative justices. I think replacing Justice Kennedy, likely with Brett Kavanaugh, is going to mean we're not going to have a swing justice for the foreseeable future. Beginning with last term, and for the era to come, there's going to be 5 solidly conservative justices across the whole range of constitutional issues to come before the court. This era, too, is likely to last a long time. Clarence Thomas is 70 years old, Samuel Alito is 68, John Roberts is 63, Neil Gorsuch is 50, and Brett Kavanaugh is 53. It's possible to imagine these 5 justices being together for another decade or 2. So I guess the bottom line is, if you're conservative, this is a time to celebrate. This is what conservatives have wanted to see with regard to the Supreme Court for a long time to come, and now it's upon us. And if you're liberal, maybe the best to hope for is that the Supreme Court will continue to take fewer and fewer cases and decide them each year.
So Justice Gorsuch just completed his first full term, though. What impact do you think he has had on the Supreme Court so far?
He's had an enormous impact. Imagine that instead of it being Neil Gorsuch, it had been Merrick Garland, even somebody more liberal. Think of all of the cases that we're going to be talking about today. The travel ban case, the cases with regard to the First Amendment, partisan gerrymandering, all of them would have come out differently. This again goes back to where I started. Elections and the Electoral College really matter.
Dahlia, Fred, do you have a different take or anything to add to that?
Well, this is the 18th year that Erwin and I have done this together, and it seems to me that on many occasions it's fallen to Erwin to express concerns about where things may be headed, and I've tried to put an optimistic gloss on it. I'm done. So I'll start with making a public acknowledgement. Years ago, in this session, we talked about what then relatively new Chief Justice John Roberts might be like and where he might fit in on the court. And I recall at that time that I said, you know, he clerked both for William Rehnquist and Henry Friendly, and that both of those influences could play a role in him, and we might very well see the Henry Friendly influencing Justice Roberts on into the future. Erwin had a different view, so now let me say you were right and I was wrong. Almost entirely. We still see little glimmers with John Roberts, who I think will be the swing justice now. Swing just mean arithmetically. I mean, when you look at the court, he will be in the middle of the 9 justices. Swing in the sense of a Lewis Powell, of a Sandra Day O'Connor, and more recently of an Anthony Kennedy, certainly not. But for those with long memories, if you look back at a certain period of the Warren Court, this is just to put some perspective in this, the swing justice, the middle justice arithmetically was, I'm glad you're all sitting down, William Brennan, with 4 to his left and arguably 4 to his right. So we have traveled a long path, but I also say this, that for those who are not celebrating now and just watching your body language while Erwin was talking, for those of you for whom this is sort of half constitutional law scholarship setting and half Shiva, that history is long, and that arc of which Dr. King and more recently President Obama spoke continues, but it's longer than we might have thought.
So we're going to come back to Judge Kavanaugh at the end. Let's start talking about some of the biggest cases of the term. And Fred, I'm going to start with you on that.
Well, the first one to start with, and I'll talk about 2 Supreme Court cases in the immigration area, and then a number of cases, and by no means all, in the immigration area broadly, because there's a lot of action in the lower courts on this. But the first one, Trump against Hawaii, the travel ban case, picks up exactly where Erwin left off, saying, imagine Merrick Garland instead of Neil Gorsuch, because the travel ban case is a 5-4 decision, and it is our classic 5, if you will, with the Chief Justice writing the opinion along with the 4 other conservatives. The travel ban case in some ways was the one we knew from the beginning that we would be talking about, and in some ways we knew we'd be talking about that 2 years ago. In fact, those involved in legal education will trace back to the very early days of the Trump administration, the spectacle of law students with laptops sitting cross-legged on the floor in major airports like JFK. And yes, people get a little emotional talking about this. And it really was a sign of how lawyers could make a difference and young lawyers could make a difference. And I think there is no question at all that that has played a role in rising numbers of applications to law school, which for many years had begun to tail off. Very interesting to see this increasing, which for those of us still involved in legal education to a certain extent is a bright spot, and for deans of law schools is a very bright spot, since some of them pay tuition. The travel ban case is the 3rd iteration of a travel ban, as many of you will recall. The 3rd version of the travel ban was the one that was most sanitized. It was not all Muslim-majority countries and not only Muslim-majority countries. It was designed to have certain exceptions, but it was within a context that I think was very clear, going back to the very early days, literally the first days of the administration in January of 2017. Challenged on 2 grounds. One was the authority under the immigration laws for the administration to put the travel ban in place, and then the other, particularly relevant to an ADL audience, was the Establishment Clause argument that, in fact, it was a ban that was aimed at a religious group. The majority of the court finds for the administration, upholds the travel ban by a vote of 5-4 on both grounds. One, with respect to the broad reading of the executive power in the immigration area, and I think on this there is fairly broad consensus, even though some celebrate, some wince right now, but there is broad federal authority given to the executive branch with respect to immigration power. There is a dissent by Justice Breyer on some technicalities of what, in fact, the travel ban did and what was being taken into account in the travel ban. But let me come to the core of the matter for us, which was the question whether this was a religious discriminatory ban against Muslims. The majority looks at the face of the travel ban and says nothing in there about Muslims. And the administration's position is not on its face religiously discriminatory and upholds it on that basis. There is, the only word I can think of is a searing dissent from Justice Sotomayor, who looks at the McCreary case as a point of departure, one known to many of us in the room, a Ten Commandments case in 2005, saying that purpose is not the only thing we look at in these cases, but it is one of the things we can look at. It can be highly relevant to understanding what's going on in these cases, and look at the entire context of publicly available statements of the administration during the campaign by the president, during the early years of the administration, and that clearly, in fact, the expression Muslim ban is not one that I made up. The expression Muslim ban was the sort of classic expression that was used by officials to describe the travel ban. And therefore, Justice Sotomayor in her dissent says if we look at the faces of what was going on, clearly this was a religiously discriminatory ban. 5-4, it is upheld. The change there of Justice Kennedy, who is already in that group of 5, that decision comes out the same way in the next term and going forward. The other case, Jennings against Rodriguez, we can deal with a little more simply. It looks on its face like a statutory interpretation case about non-citizens who have been held pending deportation and what the restriction should be on whether they get bail hearings or not. And the statute doesn't say anything to that effect. But you have those people being held for extensive periods of time. So the Ninth Circuit upheld a preliminary injunction from the lower court saying that it can't possibly be that these people can be held essentially without limit, without bail hearing, and without any consideration about whether they should be granted bail. By a vote of 5-3, the Supreme Court reverses. Justice Kagan recuses herself, so essentially it's the same 5-4 group that we're used to. This is a Justice Alito majority opinion. The court finds that there is nothing in the immigration law that puts a 6-month ban, which is what the Ninth Circuit did, 6-month limit on when a bail hearing would have to be held. There is nothing in the statute that calls for what kind of proof would have to be shown by the government in order for these people to continue to be held. And therefore, we read the statute as it is essentially unbridled authority for the executive branch in this area. And that is upheld by a vote of 5-3. And again, just to make the point, the change in the composition of the court here, again, doesn't change anything. Going further to the right doesn't matter. We have the same result there. There's a whole range now of cases in the lower courts in the immigration area, and I'll just refer to some notes on these because they are extensive. I'll talk about 4 areas, and I'll do these relatively quickly, but there's a lot that's happening out there. In fact, Dahlia was saying backstage, what an interesting time to be a district court judge. In some ways, the most hopeless because it's going to go up to the Supreme Court, but I think that's misconceived. I think in some ways the most powerful because of the kinds of cases that they have. So DACA, the Deferred Action for Childhood Arrivals, or so-called Dreamers, is one area. Their cases, sanctuary city cases, have been a number that I'll tick off briefly. The temporary protected status cases, and then holding last and in some ways most emotional for many of us in the room, and certainly most of the moment, the family separation and detention cases. So let me just review some of these. First on DACA, if I may just take a point of personal privilege to say from the Phi Beta Kappa point of view, what's at stake with DACA. Trinity College in Washington, D.C. inducted 13 new members of Phi Beta Kappa this past year. Of those 13, 7 were Dreamers. As a recognition of what it means to recognize excellence in our society, and has always, it seems to me DACA has to be seen in that context. a case that will be near and dear to Erwin's heart in the University of California system. Coming out of the Northern District of California is a major preliminary injunction requiring that the government maintain DACA. That's a case that has been argued before the Ninth Circuit, and we're awaiting decision from the Ninth Circuit. But I will just mention that in some ways the lead plaintiff, if I might, I know the lead plaintiff is the University of California, and the regents of the university, but that means President Napolitano, former Secretary of the Department of Homeland Security, so somebody knows a little something about Homeland Security, and the University of California playing a leadership role in that area. A second preliminary injunction was issued by a federal district court in the Eastern District of New York. That case has been briefed to the Second Circuit and is awaiting scheduling for oral argument. And then the last one I'll mention quickly, related cases, NAACP against Trump and trustees of Princeton University against the United States, where John Bates in the District of Columbia issued an order in which he terminated the memorandum, ordered the termination of the memorandum that vacated DACA. All of these obviously are cases that bear watching, and on the other side of the spectrum with DACA is a case going forward in the Southern District of Texas, class action brought by a large number of states, 10 states, challenging the legality of DACA, and not surprisingly, but significantly there, in June, the Justice Department declined to defend DACA in that case. Sanctuary cities. In January of 17, the very early days of the administration, an executive order, among other things, attempted to withhold funding from so-called sanctuary cities. 3 cases that are noteworthy, again, one from California involving Santa Clara County and the city and county of San Francisco that enjoined the implementation of the executive order with respect to withholding funds from sanctuary cities. A Chicago case, similarly enjoining the Attorney General from imposing notice and access conditions on certain funding, which was upheld by the Seventh Circuit. And here in the city of brotherly love, I have to mention a case in Philadelphia itself, in which the district court barred the Attorney General from imposing the funds being withheld under that executive order. Temporary protected status case involving the Homeland Security order that would rescind temporary protected status provisions for Salvadorians, Haitians, Hondurans, and some other groups. That case challenging that decision is ongoing. And last, and as I say in some ways most, is what's happened in the family separation and detention area. I cannot be the only person in the room who has been struck by the juxtaposition that the entire world has collectively and properly held its breath while 12 young people were rescued from a cave. And yet we are living in a time where thousands of young people have been separated from their parents. And if I may, again, on a note of personal privilege, for many of us in the room, the spectacle of children being taken away from their parents cuts a little too close to the bone. There have been injunctions entered, most notably the Judge Sabra in the Southern District of California, whose injunction called for children to be reunited with their parents. By the way, today is not only the significant because it's the day after the appointment, it happens to be the day on which children under the age of 5 are to be reunited. The Justice Department and the government informed the court that of 102 young people who fit that description, 54 of the parents have been identified. So they will not make that deadline. And by the end of the month, there are over 3,000 who have to be reunited according to that court order. And I should also add in terms of the timing that it wasn't just the appointment or the naming of a new Supreme Court justice last night that caught the attention of many of us. Judge Dahlia in the Central District of California issued a decision yesterday rejecting the government's request to alter the Flores settlement. Going back to 1997, the Flores settlement which puts a limit on how long children may be held. She described it as a, her words now, cynical attempt by the government to shift responsibility for 20 years of congressional inaction and ill-considered executive action. So there is still a major role for Article III courts to play in issues that will continue to be compelling and play out the most significant issues that affect all of us.
Thank you, Fred. And yes, that was indeed a positive glimmer last night. I want to give Erwin and Dahlia a few minutes to respond and add. And also, going back to the travel ban earlier, curious, if you want to, curious what you make of Justice Kennedy's concurrence in that decision.
I actually was going to start with the travel ban just to make maybe 2 quick points. One, no, I'm going to start by saying thank you, and it's great to be back.
Let's get to work, Dahlia.
Manners, Dahlia. I want to start by saying I think, and Fred said this, but I want to say it really explicitly, I think that there was a Trumpish era to some of, a sort of aura to some of the cases that the court heard, but the travel ban was the first square on, I think, challenge to Trumpism and to the idea of, you know, Trump quote Trump saying Trump-like things and making Trump-like laws, and the court taking some position on that. And if you look at the progression over the 3 iterations of the ban, you could see that with each kind of spit shine and rinse and polish to make it a little bit more palatable, all of the courts, but most especially the Supreme Court, got more and more comfortable distancing itself from taking responsibility for the most extraordinary components of that, the horrible rollout, the ill-planned coordination between agencies. All that initially, when we talk about what happened at the airports in the first days, you know, the fact that nobody knew what was going on and that there were heads of agencies who were finding out in the news what DHS or what the Justice Department itself were doing, all that goes away. And I just take it as a little bit of a cautionary tale. So I guess Erwin and I will be the bookends of doom for purposes of this year's event. But I think when we look at the analog to how family separation, similarly horrifying rollout, lack of interagency coordination, no responsibility in any meaningful way. I mean, it's clear there was never even a plan to reunify families, much less keep a database. I think that it's a good cautionary tale about the ways in which, as cases wend along, the small c conservative nature of courts, the tendency to want things to look okay so that the courts don't have to be the arbiter of Trumpism is very strong. And so even though we look at the fact that the family separation policy seemingly starts with an announcement of a policy that isn't a policy because the Department of Homeland Security can't even take a position on whether such a policy exists for legal purposes. By the time this makes its way through iterations of policies and cleanups, and the Justice Department kind of hedges and constructs a reality around it, even in retrospect, it becomes very hard, I think, for the courts to do what courts can do initially. And so I just think let's draw a straight line between the way the initial, you know, in the first 24 hours of the travel ban, 5 courts enjoined it because it was so easy to do that. By the time it comes to Justice Kennedy at the Supreme Court, it's very easy to say we're just going to look at the 4 corners of the order. We're going to blinker ourselves to the tweets and the campaign statements and things that are on the website. That is, by definition, what judges want to do. And so I think we just need to, when we have conversations, and we've had them certainly in prior years, about the extent to which the courts can be a bulwark, I think it's important to also be very sensitive to the extent to which courts don't want to do radical, dramatic things, and certainly the Supreme Court doesn't, which doesn't fully explain Justice Kennedy's decision, I think, and this goes to your question, Melissa, to sort of throw up his hands in his concurrence in the travel ban case. He writes an explicit concurrence in which he says, more or less, you know, bad stuff can happen, don't be unconstitutional, drop the mic, I'm out. And has this amazing, I think, chilling language about anxious countries around the world look on, but I'm not here to fix that. And I think, to me, that's a really useful way, sort of paradigmatic way to say that if the courts are anxious about interceding in Trump and Trumpism, this is the model. The model is, it is not an appropriate role for the judicial branch to get involved. And so that's my sort of slightly dispiriting view. The only other just factual thing that I want to tack on to what's been said, we've talked about the substitution of, when Merrick Garland is out and Neil Gorsuch is in. The other thing that I think is really remarkable about this past term that warrants flagging is the Justice Department flipping sides in one case after another. This is a practice that is frowned upon. It makes the Supreme Court very anxious to have a new Solicitor General come in and say, in this litigation, even though we've had one posture for decades, we're going to take a completely different posture here now. It's something that even the justices asked about in some of the cases this year. How is it possible you flipped sides? But to the extent to which we saw unprecedented amount of the Justice Department having long-standing posture in cases, suddenly taking another posture, I think is, again, very, very symbolically important in terms of the willingness of Trump's Justice Department to just kind of put aside the patina of we are above raw politics, Pox, Jeff Rosen, but we are above raw politics. We are doing something different when we talk about the law and the Constitution. When the Justice Department is willing to switch lanes this readily and this quickly in case after case, I think it's a dramatic shift and one that is worth noting.
I just want to make a brief point about the legal basis for the decision in the trail ban case and what's likely to mean for the future. The evidence was overwhelming that Donald Trump wanted a Muslim ban. He repeatedly said he wanted a complete ban on Muslims being able to come into the United States. The day the travel ban executive order was promulgated, January 27, 2017, Rudy Giuliani went on national television and said he was asked by President Trump to come up with a Muslim ban that would get through the courts. Justice Sotomayor does a terrific job in her dissent of just listing all of the statements by the Trump administration and by Donald Trump saying he wanted a Muslim ban. So how does the Supreme Court ignore this? Chief Justice Roberts says when it comes to presidential decisions as to immigration, only rational basis review is to be used. The government virtually always wins under rational basis review. Under rational basis review, the government will win so long as its action is rationally related to a legitimate government purpose. And under rational basis review, the government's actual purpose is irrelevant. Any conceivable legitimate purpose is enough. So the fact that the actual purpose for the travel ban was a Muslim exclusion becomes irrelevant. All that's necessary is a conceivable legitimate purpose, and the court says that's national security. Well, think of all of the other areas where Fred talked about. If it's only rational basis review, remember, the government always wins. All the government needs is a legitimate purpose, and being able to say, this is a reasonable way to achieve it. It then means that when it comes to immigration, all of the constitutional protections, like the Establishment Clause, become irrelevant.
Dahlia, coming back to you, turning now to one of the bedrock issues in our democracy, voting and elections. The Supreme Court had several really important decisions this term on voting rights and redistricting, including one that was decided on the 5th anniversary of the court's decision in Shelby County, Abbott versus Perez. ADL had actually joined a brief in Gill versus Whitford, urging the court to set limits on partisan gerrymandering this year. So what did the Supreme Court say this year about voting rights and redistricting, and how might that impact our elections going forward?
I think that one of the most consequential, probably underplayed stories was the hit to voting rights this year. There were a trifecta of cases. There was Gill and Benesek, which were supposed to be the ultimate. We were finally going to get a resolution to this question of whether there was a standard for what a partisan political gerrymander looked like. Then we had an Ohio voter purge case called Husted, and then Abbott. And all three of them were losses for voting rights. And I think it's also maybe just worth pointing out, at least some credible reporting that I had done last year suggested that one of the reasons Anthony Kennedy actually stayed an extra year. You remember we sat here last year and talked about rumors that he was going to retire. There was some reason to believe he really wanted to stay to do partisan gerrymandering, and that is because going all the way back to 2004, it was Anthony Kennedy who, in the partisan gerrymander context, said, look, I think that there is some constitutional injury here in the world of partisan, these are not racial gerrymanders, these are political gerrymanders, but I don't know what a justiciable standard is. I'm looking for a test. So let's kind of put a pin in this and bring me a test, world, which is a very Kennedy-esque thing to do. He does it in various contexts. And then I think the world, because Justice Kennedy was the decider, brought him tests. And finally, we had one in Gill that looked as though it was going to be the justiciable standard that he was searching for, to finally have a kind of empirical marker of when something was an unconstitutional partisan political gerrymander. And so in Wisconsin, after the 2010 election, and districts were, new maps were done and districts were gerrymandered, we had in 2012 Republicans winning 48% of the electorate, but getting 60 of the 99 seats. 2014, Republicans win 52% of the electorate, but somehow get 63 out of the 99 seats. So it's clear that we're looking at gerrymanders that are constructing a permanent majority. And Gill comes to the court with with a test that's called an efficiency gap. So this is a metric that is going to be able to finally test empirically how many wasted votes we have subject to a political gerrymander. And the test is sort of the words you probably heard were cracking and packing, right? How we create districts that are either, we either sort of spread Democrats around so that their votes are diluted, or we pack them all into one district so their votes are diluted. And this was meant to be the mathematical formula with the angels and the harps and the puffy clouds that finally allowed Anthony Kennedy to say, you know what, this is a bridge too far. This is the partisan gerrymander standard I've been looking for. You may remember at oral argument when Gill was argued, Chief Justice John Roberts went after social science gobbledygook, enraging social scientists for a generation, but sort of feeling like this mathematical formula and all these tests would lessen voter confidence in the system. And the court surprised us by taking a second gerrymander case while Gill was pending. They took one out of Maryland. There was some reason to believe they took the second case because this involved a Democrat gerrymander, and so we could sort of be bipartisan and have one that was a Republican, one that was the Democrats gerrymandered someone out of office, and also that there was a strong First Amendment speech valence in the Maryland case, and when the court heard the second case this spring, it became clear that Anthony Kennedy was losing heart for this whole proposition. And the case was eventually decided by the Supreme Court. Gill was decided, basically just kicked away. No standing. We can't find a particularized injury here in Wisconsin that we can correct. So go back and see if you can find some way to find us somebody who was harmed. Elena Kagan writes essentially a roadmap that is like, here's how you do it next time, and tries to lead us to a different conclusion. But again, that assumes that Anthony Kennedy's vote is in play, which it will not be going forward. So I think, and they kicked back the Maryland case saying, well, we don't have a standard. So there was no resolution in that case, and we also, I think, have lost that fifth justice who might have been apt to find a partisan political gerrymander. Just briefly, the Ohio vote purge case is almost more pernicious. It got less play But this was the state of Ohio simply doing what more and more we're going to see happen, which is throwing voters off the rolls. This was ostensibly done to clean up the rolls. The state took the position that they wanted to figure out who'd moved. And as a proxy to determine who had moved, they were going to use non-voting as a signal that folks had moved. And so the system they set up was that if you've had no voting activity in 2 years, they send you a little card. Most people did with the card what I do with the card, which is throw out the card without looking at it. If you don't return the card to the state and say, no, I haven't moved, I'm still here and I'd care to vote in future, and then you don't vote for 4 more years, you're purged. And a lot of the folks find out that they're purged when they show up to vote. One of the plaintiffs in this case had actually been serving his country abroad when he didn't vote. But it was challenged under federal statutes that say you cannot, in fact, deny people the right to vote based on non-voting, and the Supreme Court decided this case essentially saying, oh no, it's just a proxy for whether you've moved. We'll just use it, we'll take the state at its word that that's how they were measuring and what they were measuring. Again, we've talked a little bit about Sonia Sotomayor, but just a blistering dissent from Justice Sotomayor pointing out that the people who unerringly get purged in these kinds of regimes are minorities and the very poor and students and the elderly and the kinds of people who seemingly don't necessarily support Republican state government. And she really, I think, made a point of calling out the majority for the ways in which this transparent, in her view, system to punish minority and poor voters was being blessed, because it will be, she cautioned, and I think it without a doubt will become the basis of similar voter purges in other states all around the country. The folks who litigated this case made a point of saying, when I talked to them on my podcast, that these kinds of vote purges are really hard to litigate. These cases are unbelievably costly and difficult to litigate. This is not a simple matter. Finally, just the Texas case, again, I think file under the states can do what they want kind of doctrine of voting going forward, but this was just simply on the 5-year anniversary of Shelby County, the court ruling on racial gerrymander in Texas that very heavily implicated Latino voters, and the court again more or less said, we're good, it's fine, there's one little problem to tweak, but we're okay with the entirety of this gerrymander. And Justice Alito, writing for the court, essentially saying we're going to presume good faith on the part of states when they draw these maps. And you're going to have to make a showing, an incredibly high bar of really brutal intent to discriminate. So I think if you look at those 3 cases in the aggregate, it really does feel that there is, and I can't put too fine a point on it, that there is a doctrinal tendency to just give up on the proposition that voting matters. And remember that all this was happening at the same time that we had a massive, bless you, vote fraud commission that was seemingly investigating the scourge of vote fraud that does not exist in this country. And the commission eventually stopped doing it. But I think you have to look at these cases as a sort of concerted claim, I think, by the courts that they're out of the fair voting business on the one hand, and also that persistent lack of voter confidence in the voting system. All of the ways that we are being told over and over again that votes don't matter and that systems aren't fair really, I think, resoundingly got a thumping win voter confidence that their systems are fair and representative, that we have a one-person, one-vote regime in this country that doesn't discriminate, just took a crippling, I think, blow. And voters who are discouraged are right to be discouraged.
Wow. Nobody thought that this was going to be a positive, but moving, in the interest of time, Erwin, let's go now to the First Amendment and free speech issues, which were at, surprisingly, the heart of several decisions this term affecting reproductive rights, LGBT rights, and workers' rights. ADL had joined Amicus Briefs and Masterpiece Cake Shop with civil rights and religious groups, and in NIFLA with women's rights groups. So what happened in these cases, Masterpiece, NIFLA, and the Janis case, and what do they tell us about the court's thinking about the First Amendment?
In a dissenting opinion, Justice Kagan referred to the weaponizing of the First Amendment. What she meant by that was using the First Amendment to strike down economic and social legislation. We saw that this term, and I think very much as the harbinger of what we see in the future. Let me take the cases in the reverse order that you mentioned them. Let me start with Janis versus American Federation. In 1977, in Abood versus Detroit Board of Education, the Supreme Court reaffirmed that no one can be forced to join a public employees union. But the court said that non-union members can be required to pay the share of the union dues that go to support the collective bargaining activities of the union. The court said non-union members benefit from collective bargaining. Their wages, their hours, their working conditions, they shouldn't be able to be free riders. The court said, though, that non-union members can't be required to pay the share of the union dues that go to support the political activities of the union. The court said that would be impermissible compelled speech. In Janis, the Supreme Court, in a 5-4 decision, overruled Abood. Justice Alito wrote, joined by the conservative justices. Justice Kagan wrote for the dissent. Justice Alito said that Abood was wrong when it was decided, and it should be overruled now. He rejected the argument that there's a sufficient justification in preventing free riders or in keeping labor peace. Justice Kagan wrote a vehement dissent. She said that the Supreme Court had no basis for overruling the precedent, that Abood had been relied on in thousands, tens of thousands of public employee contracts. She said the court did this just because, quote, it wanted to. This is a case that's going to have an enormous practical effect. It's going to decrease union membership and union revenues. It's going to lead to a great deal more litigation. Just last week, 10 lawsuits were filed by those who opposed Abood, claiming that union members who paid the fair share before are entitled to get the money back in money damages. If those suits succeed, it will bankrupt many unions around the country. In his majority opinion, Justice Alito suggested that the core of the National Labor Relations Act, exclusive representation and bargaining by unions, also violates the First Amendment. Those challenges are pending in lower courts as well. The second case that I wanted to talk about that you mentioned is the National Institute of Family and Life Advocates versus Becerra. It involves a California statute, the Reproductive Fact Act. It says that facilities in the state that provide reproductive health care to women have to post a notice saying the state of California makes available free and low-cost abortion and contraceptives for women who qualify. Also, unlicensed facilities have to post that they're not licensed to provide health care. No one is required to say anything. No facility is required to provide contraceptive or abortion counseling or referrals. They just have to post this notice. The legislative history says that there are over 200 so-called pregnancy crisis counseling centers in California. They are affiliated with religious organizations, and they often provide women inaccurate information, including about the health risks of abortion. The Supreme Court, 5-4, essentially declared it unconstitutional. The court said injunction should have been given is against the law. Justice Thomas wrote for the court, joined by the conservative justices. He said the disclosure requirement is a content-based restriction on speech. It specifies the content of what has to be posted. He said content-based restrictions on speech have to meet strict scrutiny. They have to be necessary to achieve a compelling government purpose. He rejected here that there was a compelling purpose or the law was necessary. He said that this was impermissible compelled speech. He struck down the requirement of the notice with regard to the availability of contraception and abortion for women who qualify. He even struck down the requirement that unlicensed facilities have to inform women of that fact. Justice Breyer wrote the dissent, and his point was there's countless laws that require disclosures in innumerable contexts. All of them, by definition, are content-based because they're all prescribing the content of the expression. All of these are vulnerable, whether it's the requirement that restaurants post calorie counts, or that workplaces inform employees of their rights, or that bars inform people of the health consequences of alcohol. All of these become vulnerable. I think the only way to understand what the Supreme Court did in this case, in light of other laws upholding regulation of professional speech, is seeing as based on the conservative majority's hostility to abortion rights. The final case, and the first that you listed, was Masterpiece Cake Shop versus Colorado Civil Rights Commission. A gay couple in Colorado went to Massachusetts to get married. They did this at a time when same-sex marriage was allowed in Massachusetts, but not yet in Colorado. They went back to their home state to celebrate their wedding with family and friends. They went to a local business, the Masterpiece Cake Shop, and asked the owner, Jack Phillips, to design and bake a cake for them. He refused to do so. He said it violated his religious beliefs that it would be same-sex marriage, and he would be complicit if he designed and baked a cake. Colorado, like many states, has a law that says that business establishments can't discriminate on the basis of race, sex, or religion, or sexual orientation. The couple filed a complaint with the Colorado Civil Rights Commission. There was a lengthy administrative process through many steps. Ultimately, the Colorado Civil Rights Commission ruled in favor of the couple and against Masterpiece Cake Shop. The Colorado Court of Appeals affirmed. The Colorado Supreme Court denied review. The Supreme Court, in a 7-2 decision, reversed. Justice Kennedy wrote the opinion for the court. He said that the Colorado Civil Rights Commission had expressed impermissible hostility to religion. Hostility to religion violates the Free Exercise Clause. But it's very important to focus in this case on what was the evidence of hostility to religion. He pointed to three things. First, at the initial hearing before the Colorado Civil Rights Commission, one commissioner said, anyone who wants to do business in the state of Colorado has to serve all customers. That, of course, is what Colorado law said. That's hardly hostility to religion. The second thing he pointed to is a statement at a later hearing where a commissioner said, many terrible things have been done in the name of religion. Slavery and the Holocaust have been justified in the name of religion. It's sad, but it's a true statement. Finally, he pointed to some other cases where the Colorado Civil Rights Commission ruled in favor of bakers who refused to bake cakes with particular statements. But as Justice Kagan points out in her concurring opinion, in none of those instances were the bakers refusing to bake cakes based on race, sex, religion, or sexual orientation. In none of those cases, in other words, was there a claim of violation of the Colorado Public Accommodations Law. I find it striking to compare the minimal evidence of religious hostility in this case with the very great evidence of religious hostility in the travel ban case, which the court then upholds. The underlying issues in this case were unresolved. Does it violate free exercise of religion to force someone to provide services if it violates his or religious beliefs? Does it violate freedom of speech to compel somebody to provide services? Justice Thomas and Gorsuch addressed the latter, and they said they believe it would violate free speech under the First Amendment to force the baker to bake a cake against his religious beliefs. If ever this gets a majority of the court, it will have stunning implications. After all, if baking a cake is expressive activity, then isn't making floral arrangements for a wedding, or taking pictures, or engraving invitations? If baking a cake is speech, isn't cooking food speech? Do you remember the old Ollie's barbecue case in the mid-1960s? It involved a restaurant in Birmingham, Alabama that refused to admit or serve African-American customers. It said that it should have the right to not serve those it doesn't want to provide service to. The court rejected that. But if forcing a business to provide services is speech, why wouldn't it have the First Amendment right to refuse to provide service to African Americans? There's always a tension between liberty and equality. Anytime we prohibit discrimination, we're limiting the freedom to discriminate. Our society has made the choice for over half a century that equality is more important than the freedom to discriminate. What Justice Thomas and Gorsuch are saying is that's wrong. There should be a freedom to discriminate. The court didn't resolve the underlying issues, but I'm very worried for the future.
Before we move on, I want to stay on this for just one more minute. Dahlia and Fred, do you have a different take, or do you agree with Fred, Erwin here?
No, certainly not a different take. And in fact, I would continue along the lines where Erwin ended and situate this in a larger context, because I think, in fact, what's really at stake is nothing less than the project to undo what had been established law, the generally applicable laws that may have different kinds of impact on people's religious lives are permissible and constitutional. That has been under attack for decades. And I think Masterpiece Cake Shop in some ways can be seen as part of that project. That's the Smith case in 1990, and there's sort of an opaque reference in Gorsuch's opinion saying many have questioned the continued vitality of Smith. Where is that coming from? I think those are seeds that are being planted for the future. So I share the concern as to where this leads, and I think it is the lead edge of a much bigger and very disturbing project.
I think I would only add that both NIFLA, the Crisis Pregnancy Center case, and Masterpiece are really perplexing in that they initially come to the court as religion cases. They eventually get briefed and argued as religion/speech cases. The Supreme Court takes them as speech cases, and then they get decided as some kind of amalgam of religious speech cases. Right. And I think that we just want to be really careful, especially if we're talking in the ADL context of how we think about religious liberty, to just watch for that slippage and the conflation of what should be very clear categories. Or, is this a speech case? Is this a religious case? And I think that these cases really get very, very confusing very quickly when you're saying there's some kind of special religion/speech doctrine that is emerging that is separate from the undergirding doctrine that we think about in these categories. And I just think if you, again, layer that against the travel ban, where you have what is overtly religious animus and speech, except this time it's directed at Muslims, right. To not think about what it means that we are creating some class of religious speech cases that don't apply to the president when he overtly says, I'm going to have an all-out ban on Muslims entering this country. It's not just, fear for sort of disassembling the legal architecture of the public accommodations laws. That's one thing. But I think it's also opening the door to a kind of very, very tricky double standard about what kind of religious-ish speech is going to be tolerated and what isn't.
That's a great point. Fred, you have the pleasure of talking about the rare positive glimmer for civil rights and liberties this term and the court's decision in Carpenter versus United States. So
right. I guess I did something good in a prior life. I get the good case to talk about, the Carpenter case. But in keeping with our theme for the day, there are clouds on the horizon on this too that I'll come back to. I didn't want you to get giddy there for a moment. So we'll come back to an interesting and disturbing piece in Carpenter itself. But Carpenter is a Fourth Amendment case, search and seizure case, that involved the question of whether or not a warrant would be required to get the records of your cell phone. Now, you may not think about it, but that cell phone that you're carrying around in your pocket is a terrific record of every place you've been and every place you're going, because every time you use it, and I don't just mean to make calls, anytime it does anything, right now while you think it's off, it's telling you what the stock market is doing and what the president has said last. Every time it does that, it's bouncing it off some satellite, or some cell tower. So as you move around, it keeps doing that, and there is a record of all of those. So the question is that a search within the means of the Fourth Amendment, and is it a reasonable search that would require getting a warrant on the showing of probable cause of criminal activity or evidence to adduce proof of criminal activity? The question, or the government's position was that this was in fact not a search. These are public records, your phone records, for example, that are publicly, where you call those numbers you've done, put that out into the ether. So is this like that? Majority of the court, 5-4, and this is not Justice Kennedy in the 5 who finds that there's a violation of the Fourth Amendment. So this is one that, at least so far as we can see, would not change with the composition of the court. It is the 4 liberals, along with Chief Justice John Roberts, who say that there is, in fact, a search, because after all, the first question about whether or not a search has taken place, and this goes back to the Katz case back in the 1960s, is there a violation of a reasonable expectation of privacy? And does one have a reasonable expectation of privacy in one's cell phone records? And the majority of the court, 5-4, says yes, one has a reasonable expectation of privacy, and therefore there is a requirement that one get a search warrant, the government get a search warrant before getting access to those records. So far, so good. So where are my clouds? There's a dissenting opinion that Justice Kennedy and Justice Alito and Justice Thomas filed together, but then there are 2 separate dissenting opinions, one by Justice Thomas and one by Justice Gorsuch. So that one obviously bears very close watching, and we don't know where Judge Kavanaugh would be on this, but I think it's a kind of question that is worth raising, and looking at his record on the DC Circuit, one has reasons for being cautious on this. And that is in both Justice Thomas and particularly Justice Gorsuch. There's a suggestion that Katz really has no real reading or foundation in the Fourth Amendment, which is to say that reasonable expectation of privacy language is not the right way to think about it, and we ought to go back to kind of a pre-Katz world where the question is one of physical invasion. A search takes place when somebody comes into your home, when somebody comes into your property, when somebody stops you on the street, that kind of a physicality of search, or where the question is this your property or somebody else's property? If you ask the question that way, I guess your cell phone records are sort of somebody else's property, if you're thinking of it in that kind of a brittle notion. It's been a long time since we thought of it that way. Since Katz, we've asked the question about reasonable expectations of privacy. If that is rolled back, that would be an extraordinary expansion of government authority and an extraordinary curtailment of how we've understood the Fourth Amendment for half a century. So the good news is it's a 5-4 decision that found that the Fourth Amendment did apply and that the constitutional rights are considered robust in this area. But there are clouds even on the horizon even there.
Yeah. And staying with the clouds for a minute, Dahlia, if we could go back to what I think is at the forefront of everyone's minds today, to chime in briefly to talk about the future of the Supreme Court given the Kennedy vacancy and now the nomination of Brett Kavanaugh. ADL expressed concern last night about Kavanaugh's hostility to reproductive rights and past support for greatly expanded unchecked executive power. Curious what your immediate impressions are of the nominee and how you foresee this retirement impacting the future of the court.
I'm smiling because I'm terrified. I think just looping back to something that Erwin said at the beginning, I think if you think about the fact that the median justice on the U.S. Supreme Court for the foreseeable future will be John Roberts, who has been in the famous Richard Posner study of the most conservative justices in the last 100 years, certainly in the top 5. So that's the median justice. I think the question quickly arises, what are the issues in which Anthony Kennedy, who was, by the way, I think ranked 11 on that Richard Posner study, but nevertheless, he defected and voted with the left on certain areas. So what are those areas that are up for grabs? And reproductive rights, I think, are certainly one. I think affirmative action, without a doubt, Justice Kennedy was the 5th vote for enduring role for affirmative action in higher education. I think there's genuine reason to think that he was the 5th vote to protect expansive readings of LGBTQ rights. going forward. I think, as I suggested, he was at least the hope of the fifth vote in the voting rights context, in the gerrymander context. And I think he was also, and we sometimes forget this, an important fifth vote in a whole bunch of cases that had to do with how we treat incarcerated juveniles, whether we can execute juveniles. He was inching toward having, becoming an important voice on the court about solitary confinement and conditions for prisoners. So really all that I think is back on the table, and not to put too fine a point on it, but I don't think John Roberts is in play on a lot of those issues. And I think the other thing that's just worth saying is that the conversation we're about to have during the confirmation process about things like stare decisis and the future viability of Roe v. Wade or Casey, all of those conversations can't simply turn on the promise that Roe v. Wade or Casey is a precedent of the court. In other words, the magical formula that X is a precedent can't be enough of an answer because, as Erwin just said, willy-nilly the court overturned a bood this year, overturned a union's precedent that was almost as old as Roe v. Wade. So I think we're going to have to figure out the nomenclature of getting beyond the simple assurances that X is precedent of the court. And the conversation that we're having right now about John Roberts won't necessarily be a fifth vote to overturn Roe or a fifth vote to undermine Obergefell, I think misses the point. A, you can do away with Roe without overturning Roe, and we saw that, by the way, in the voting rights context long before Shelby County came. The court was inching into the Voting Rights Act. So you can do it without expressly overturning something that is precedent of the court. But B, and most importantly, that statement, I think, has now been demonstrably proven to be something can be a precedent of the court and also fair game. Be very aware that we have nominees for the lower courts who are now not only declining to talk about whether Roe is precedent, but now we have a nominee declining to say whether Brown v. Board is good precedent, because I guess de jure racial segregation in schools is coming back to the courts. So look at where the line has moved in terms of what we can't talk in a meaningful way about. So just very briefly, and then I want to hear what my co-panelists have to say about this. I would just say that Brett Kavanaugh has the benefit, and this is a genuine benefit, compared to some of the other folks on the short list, of having a very, very lengthy paper trail. He's been on the court for 12 years. He has 300-some written opinions that we can scrutinize. And then I think Dick Durbin once dubbed him the Zelig of presidential power, because wherever you looked for a time, there was Brett Kavanaugh. So he had a role in Bush v. Gore. He had a role in Elian Gonzalez, that case. He had a prominent role in the Whitewater investigation and in what became the Starr Report. So there's nowhere he hasn't been in terms of really key questions about the White House. And I just want to say, for purposes of thinking about layering his experience and his writing against questions that will emerge from the Mueller probe, so questions about, Donald Trump's assertion that he can pardon himself, the assertion that a president can't be charged with a crime while in office, even assertions about the nature of what obstruction means. To the extent that those questions are going to eventually be sorted out in the courts, Brett Kavanaugh has a very significant body of writings on some and many of these issues. So I would say just don't laser focus on Roe, because I think that there are real questions about the unitary executive theory, which is being trotted out, about Chevron deference. These are all doctrinally really complicated, and I'm going fast. But I think just that to get too focused on what a 5-4 court is going to do to reproductive rights or to the environment, I think is to miss a really novel set of questions about Donald Trump's assertions that he makes over and over again about an almost unchecked scope of executive power. And those are things about which Brett Kavanaugh has written a good deal. So that's a start.
Yeah.
Okay.
Erwin and Fred, what do you think?
In January 2006, I testified against the confirmation of Samuel Alito for the Supreme Court. At a break in the proceedings, then Senator Joe Biden came up to me and said, "This is all an exercise in kabuki theater." He said, "Everyone in this room knows that Samuel Alito is going to be a very conservative justice. The Republicans are pretending that he's independent and has no ideology. So the Democrats are trying to ask questions to trip him up, but he's too smart for that. I think we have to insist that the Senate not exercise kabuki theater again. I think we should insist that the Senate require that Brett Kavanaugh answer questions about his views and ideology. When Neil Gorsuch was up for his confirmation hearings, he wouldn't answer questions even about Brown versus Board of Education. There is nothing in the Constitution or any law that says the nominee can refuse to answer questions. The Senate can insist as a condition for confirmation." Think about it for a moment. What would be the arguments that a nominee should be able to refuse to answer questions? Well, one would be that a justice's views and ideology have nothing to do with his or her decisions. We know that's not true. We know that justices have tremendous discretion, and their life experience, their views, their ideology makes all the difference in the decisions they come up with. A second possibility is to say, well, maybe he has no views on the subjects we're talking about now, like abortion, affirmative action, voting rights. We wouldn't want someone like that on the Supreme Court. When Clarence Thomas and David Souter went through their confirmation hearings, they each said they had no views on the issue of abortion. Then President of the National Organization of Women, Patricia Ireland, said, well, there's 2 adults in the country without views on abortion, and they're both on the Supreme Court. It's not credible to believe that he doesn't have views on these issues. A third possibility, which we hear the most, is it would make him biased when these cases come before the court if we knew his views. But think about it. We often know what justices' views are on issues, but that doesn't make them impermissibly biased. We know how Ruth Bader Ginsburg or Clarence Thomas are going to vote on the question whether Roe versus Wade should be overruled, but no one would say that makes them biased. Pretending that somebody doesn't have views doesn't make them unbiased. Not knowing their views doesn't make them unbiased. So I don't think you should be asked how he'll vote in a particular case in the future. That's obviously going to depend on the specifics of the matter and how the briefing and arguments are done. But I don't know any reason we can't say if you were on the court when Roe versus Wade was decided in 1973, how would you have voted then? If you were on the court when Grutter versus Bollinger was decided in 2003, how would you have voted then? Or all of the other important issues where we should know what his views are. I think it's time to stop the kabuki theater. And I think it's up to us to pressure the Senate to say, require answers or don't confirm.
Fred, do you have anything to add?
Right. Well, very briefly, and maybe it's appropriate, I'll make 2 notes. One is even more depressing than what Erwin just said. And then the final, because I was raised to believe what's the point of having a heart if not to have it broken once in a while, is some uplifting or perhaps challenging note. So the part that's more depressing is everything that Erwin said is perfectly true and perfectly pointless in 2018. And I mean that with love and the most respect, which is to say what we both know. And I'm not really, not criticizing. What we both know is that the kabuki theater will go forward because it won't make any difference. You can, in fact, pressure your senators to say, to ask the questions they should ask, but the most important arithmetic in that room is 51-49. And in fact, it's even harder than that if one looks at Democrats who have a very difficult time, purposely put in a position of a very difficult time in this particular case. And although there are 2 Republicans who are often mentioned who might vote in a different way on this, that's happened on certain issues, not on judicial confirmation. So it seems to me in 2018, the kabuki theater will go forward and we will all play our parts because, as the Israelis like to say, ein brera, there is no alternative. Here's the uplifting part. If you look at the piece in the Times today about it took a village to raise Brett Kavanaugh, which is to say this is a movement that goes back decades. He didn't come out of nowhere. This has been a long-standing movement of training a certain kind of intellectual, furthering a certain kind of career, and establishing a whole phalanx of people in a position to step up to do this. If people care deeply about these issues on a different side, they are going to have to do something about it. And this is going to have to be an issue that is more relevant to electoral politics than many on the left, or I would even say on the center left, have made it in the past years. Lip service has been given to it, but at the end of the day, it has not had the fire that it has had on the right. So, in a sense, give them their due. This victory did not come out of nowhere. This victory is the result of decades of work. So I think the answer is those who would like to see a different result had best get to work.
So we have a few more minutes for questions, and we have questions from both the audience in here and from online via Slido. So for any of the panelists, for a first question, we see this past year state attorneys general filing, been very active in filing a lot of lawsuits to challenge President Trump's policies. Do you think that this is unusual, and what kind of effect do you think it will have, sort of long term, I suppose?
Well, you certainly see it in the immigration area that I talked about, as well as in the sanctuary city area. So I think is it unusual? There was a reporter right at the beginning of the Trump administration said he wanted to have a new macro installed on his computer so that with a single keystroke he could type in an unprecedented development. Because he found himself writing it so many times that he just thought it would save time to be able to do that. So yes, of course it's unusual. It's all unusual.
Right.
But in some ways, that's what's at stake now. And I think the fact that the courts continue to play a role here should not be taken lightly. The fact that district judges are playing the role they are, and I think what Dahlia said, by the way, was spot on, that they get it in a sort of raw or unfinished form, which makes it easier to strike things down than when it goes to the Supreme Court. Nonetheless, I think that's an important role to play in terms of litigation and also in terms of the court of public opinion. I mean, in some ways, what all of these cases are also doing is forming a major educative moment for the population. Yeah. So there is that role as well.
Yeah.
There's something else going on, too. Through American history, states' rights has been used by conservatives to try to defeat progressive federal policies. Right. States' rights was the way in the early 19th century that the abolition of slavery was opposed. States' rights was used by those who opposed desegregation in the 1950s and 60s. We're seeing a change now where it's the states that are trying to use states' rights to advance civil rights and civil liberties, to advance environmental protection. And so that's new, yeah. And that's why you see the state attorney generals trying to use state law as they are. It'll be interesting to see if the conservatives respond by really becoming the nationalists, using national power. To go back to the Abood case, 22 states had laws that said that public employees have to pay the share of the union dues to support collective bargaining. Did the conservatives on the court show any deference to states' rights or the democratic process there? Obviously not.
Yeah. Can I, just one other note, and I meant to say this, file it under the column of not so bleak, is I think that we have failed to, and we should cite to, state solutions to gerrymandering, state solution. We just saw the Iowa Supreme Court just come out with a blockbuster reproductive rights decision in the past week. So I think, just to put a finer point on what Erwin's saying, did we ever think that a state Supreme Court was simply going to say, okay, we'll do the gerrymander work. So I think that we've seen that in a way that is quite remarkable. It is going to construct the law of blue states and law of red states in ways that are formidable, but I don't think it's negligible. The one other thing that we haven't said the word guns today, and that is in no small part because the Supreme Court just refuses to take a post-Heller case to help us understand the scope of gun rights. But that is an area where the state AGs, if you look at Massachusetts or other states, have done just extraordinary work cabining the reach of the Second Amendment. And so I think that is a place that we should say when the Supreme Court stood down, so to speak, in the context of Second Amendment rights, the states have done a lion's share of the work to really bolster the idea that Heller is a narrow holding that goes no further than it does.
Right. Another question here. When determining a president's intent or purpose, and this is referring to the travel ban, should statements made before the election or on the campaign trail be treated differently than statements made while in office by a court? What do you think about that?
Should, or what is the court do with that? I mean, the court essentially ignored it. I mean, it seems to me where it was fair is to say statements made in the campaign might be looked at differently from statements made afterwards. Mario Cuomo famously said, "We campaign in poetry, we rule and we govern in prose." I'm not sure that poetry is necessarily the right word for some of the campaigning that we've heard recently. But you could weigh it differently to a certain extent. But the broader question, it seems to me, and this is what Justice Sotomayor was saying in her dissent, the broader question is look at the information in the public record and try to determine what is the purpose, the plain purpose behind an activity. And there you would look at, think of it this way, what would you look at if put all of the legal issues and all of the politics aside and all of the jurisprudence aside, if you just wanted to know what was going on? As a sociologist, you just wanted to know what was going on. Surely you would look at all of that evidence to try to figure it out. So to me, that would be the best answer to that.
And staying on Justice Sotomayor for the next question, as you all have noted with your respective presentations, she had several really notable and memorable dissents this term, many now speculating that she's poised to lead the minority wing of the Supreme Court. I wonder what you think of that and sort of where you see her next term.
I think, and I'm not, it's early days, but there has been a really interesting break between Kagan and Breyer, who continue to be, attempting to reach consensus. It's funny because, at the same moment that we're talking about civility and norms in the larger national context, I think Kagan and Breyer are sort of hallmark exemplars of we're just going to try to find narrow middle ground. We're going to vote with the majority if we can kind of constrain the reach of the thing. And directly opposing that, we have Sotomayor and Ginsburg sort of peeling off and more or less saying, like, I'm not serving Sarah Huckabee Sanders at the Red Hen either. I'm not doing civility anymore. And so I think the very, very strong version of that is Sonia Sotomayor, distinctly in the travel ban dissent, just saying, I'm going to say the word Donald Trump over and over and over again because nobody else seems to want to do it. So there is a way in which I think she's become, in addition to, and we've talked about this in prior years, I think for certain she feels she must be the voice of minorities on the Supreme Court, that time and again she says, this is what it's like to be a Latina in America, and I think that has been amplified this year. But I also think in a fascinating way, she and Justice Ginsburg are seemingly more willing to just say whatever the fiction was that said that there are no parties here and this is not different. I'm not playing that game anymore.
I agree with you. When you look at Masterpiece Cake, it's 7-2, and it's only Sotomayor and Ginsburg who dissent. And yet also, if you read Justice Kagan's dissent in Janis or Justice Breyer's dissent in NIFLA, you see them being very angry. I mean, you can often tell in a dissenting opinion whether it ends, I respectfully dissent, or just, I dissent. And there you have, like Justice Sotomayor's dissent in the travel ban case, saying, I dissent. I think that these four justices feel is discouraged by the term and the future of the Supreme Court is any of us, and even more so. And I think you see that reflected in the kind of opinions they wrote.
Yeah. So unfortunately, we could talk all day, obviously, but we are out of time and have to wrap up. I want to thank again our esteemed panelists in the National Constitution Center for hosting us. The next few weeks, months, and the next term will be critical moments, as you've heard, for the future of civil rights in our democracy. We at ADL welcome your support for our work. You can receive the video recording of this event and follow up with ADL by signing up at adl.org/court2018. And I look forward to debriefing with you all next summer at our next Supreme Court review, and hopefully we will make it. So, thank you all.